Good morning. It is March 18th in Senate Judiciary. We are taking up page 2, and we have Jay from the administration here to provide their perspective.
Thank you, Mr. Chair, and good morning, committee. Thank you for having me again. I just wanted to, confirm that we're talking about H2 as reported out of the House Judiciary Committee. So I'm prepared to testify to that briefly. I first would urge you, and I know that there is some urgency, and you understand the urgency to passing this before April 1, which is when the raised age to 19 would take effect. So that's just, I think, a matter of sort of where we are and whether the support the bill in whole as drafted by the House is a little bit of a different question, but we definitely support passing this bill as quickly as possible. So I would like to get that out. With respect to the various sections, the first increases the age of delinquency, where he would be eligible for a delinquency proceeding from 10 to 12. I believe that the testimony in the House was pretty clear from all stakeholders that this would not have much of an impact on the operations. Generally speaking, I think that there is I think the Defender General's office has testified that 10-year-old or 11-year-old would not be competent to commit major crimes for purposes of in criminal in delinquency court or in criminal court. I think that it's more often a family matter, so it would be taken up in other kinds of family proceedings and other DCF interventions with the family and with the child. So I think that we felt that there really, and apparently there's never been a 10-year-old charged with murder. So we're fine with the changes as drafted. The second pushes out, or section 2 pushes out the jurisdiction on delinquency charges from 2 years to 3 years, the jurisdiction of the court. I think that's fine. I think generally speaking, DCF is saying if a young person is not treatable in 2 years, they generally won't benefit from 3 years. But I know that the length of the jurisdiction of the court is sometimes a problem because very often youth in delinquency proceedings simply age out of the proceedings and they go away. So I think no harm, no foul with that section. Generally, I think DCF would say that there are, if there may be some youth who benefit from that extension. The key section here is sections 3 and 4, with which basically repeal raise the age and the April 1 start date. So we think that is key right here. So that would be effective March 31st. I think that is essential for passage. It's very time sensitive. As you know, the governor asked for raise the age repeal, but the House would revive the raise the age system as of July 1, 2027. And Eric, feel free to correct me if I'm misstating anything. But in terms of our position, this is what we are on various sections. With respect to sections 5 through 9, this is when raise the age is brought back to age 20. Up to age 20, that's effective as of July 1, 2027. And in section 10, there are some new age as reported requirements. I don't think there were issues with those. So I have no objection to that. So generally speaking, as I said, the governor asked for repeal of raise the age. This brings raise the age back. There was a lot of testimony about the ability of DCF to actually execute on raise the age. But resource constraints aside, including the fact that we still do not have a facility and still are unable to construct one in a community that will accept 18 and 19-year-olds, I would say that raise the age has a fundamental flaw. And I think this is what I came to understand from the testimony in the House this time, is that the fatal flaw in the theory is that 18 and 19-year-olds reach the age of majority. for most purposes legally, they are adults. And we are proposing to treat them as if they were children in a juvenile jurisdiction. The juvenile court properly is rehabilitative, and youth who benefit from those services should probably be in that court system. But we already have a process for older individuals, 18 to 22, and that would be our youthful offender system that existed prior to Raise the Age. It still exists today. We believe it was changed in ways that need further reform, but there is a system for moving young adults out of the criminal system into the juvenile system. What Raise the Age does is it takes these older individuals, 18 and 19-year-old individuals, and we're only asking for repeal for 19-year-olds, and essentially moves them into a system that treats them like children where they have no accountability. They can make their own decisions. They don't have to disclose their healthcare decisions. They don't have to appear for treatment or services. There is very little that if they are not inclined to participate in services, there is very little to compel them, little or nothing actually, to compel them to participate in services. There is a way for a DCF worker to actually go to court and ask for the individual to appear in court, but the court can simply say, work with your caseworker, and the youth can walk out the door and actually wait to age out of the program, and this can continue. So this is really, I believe, the fatal flaw is unless you wanted to make 18 and 19-year-olds because of their brain development actively children legally, you are always going to have this problem in the Raise the Age program. So I believe that that's a fundamental flaw in the theory as it's been sort of presented and sold to Vermont and a few other states. I mean, Raise the Age conceptually has been happening across the country where 16 and 17-year-olds were being treated like adults in criminal court. And Raise the Age is properly happening to move those cases into family court up to the age of 18. In 2018, we were already there, right? Thanks to Senator Sears. He was an innovator in this space, and we were able to do those kinds of things much earlier than most states. We had youthful offender in 2009. So other states now are talking about the kinds of things that we have had in place for a significant period of time. So when Raise the Age came to Vermont, we were talking about raising the age to up to 19 and up to 20. If we raise the age to up to 20, we'd be the only state in the country to do it. And we clearly don't have the facilities or the partners who can do this work. But again, I think resource constraints aside, the fatal flaw is the idea that you're moving young adults, legal adults, into a family court jurisdiction where they cannot be compelled to participate in services. So that I will stop there unless you have any questions.
Thank you. Any questions or comments?
Eric Fitzpatrick, Office of Legislative Counsel. Thank you for the explanation. And I think you said this in your second half of your testimony anyway, but just the clarification that Section 3 and 4 repeal the second phase, second step, right? It's not a full repeal. Just so for the 18-year-olds that you mentioned, which went into effect in 2020, they stay in the family division, but it does repeal that second step, which is adding the 19-year-olds.
I apologize. Yeah, if that was misleading, I did intend to mean that the 19-year-old piece is.
I think you said that in your second, you clarified that as that second paragraph. Saying,
Yeah, Senator Wilson.
Should it repeals it or delays it?
Sorry, good point. Delays it until 2027.
Right, but 3 and 4 are the repeal though, and then it's reinstituted in 539.
Yeah, I think either way, both are correct. So it repeals the provision that it will go into effect in a couple of weeks, essentially. So it repeals that provision, so it won't go into effect on April 1st, 2025, and then reenacts it with a 2027 effective date. So as a practical effect, you're putting it off for a couple of years, but from a legal perspective, yes, you're repealing the piece that's supposed to go into effect shortly and reenacting it with a 2-year delayed effective date. That makes sense.
Any further questions? All right, thank you.
Okay, thank you. And I'm sorry, I won't be here to listen to most of the other testimony, but I do appreciate your participation.
Give us the highlight one more time.
Sure, sure. Morning again, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. Don't have too much to add to what they already gave you, but for the big picture for a moment or two, this is a walkthrough of H2 as it passed the House and activated the increasing minimum age for delinquency proceedings. Just to refresh everyone's recollection a little bit, the sort of foundational knowledge behind this bill is that young people are treated differently than adults when they commit an offense that would be a criminal offense if the young person was an adult. Sometimes when I say they're treated differently, that sometimes they will be treated as an adult in the criminal division, but there are other times when they will be treated as a child in the family division. So it's a way that the law treats people different based on age, which is not unusual, you know, whether it's voting or alcohol, or military service. There's a number of different places in the law where young people are treated differently than adults. This is one of them. Committing criminal conduct or conduct that would be criminal if the person or adult. So you have this age, whether or not whether it ends up in the family division or the criminal division depends on two things. And so this thing's always to keep you back in mind. Two things. What type of offense was it? And how old was the young person? Those are the two factors. What was the offense? How old?
Eric,
Yeah.
Yeah, I do. And I have a question. And you may not know the answer, but I'm wondering if you know of any of the history as to why we treat young people differently for drugs and alcohol purposes.
Not off the top of my head. No.
Okay.
No.
Okay.
That's something that some research could for sure produce something like
I
that.
wonder if it had something to do with brain development.
Could be. Could be, right? But yes, whatever reason, it absolutely is true that the law does do that. And the two factors that, as I said, go into whether or not the child ends up in the family division or the criminal division is what was the offense and how old were they? When I say what was the offense, that's another thing to keep back in your mind. And that is whether the offense was what's known as a Big 14 offense or not. And it used to be, actually only 6 or 7 months ago, it used to be known as the Big 12. It was this list of offenses that the legislature has chosen and to identify as more serious offenses that will warrant a young person starting their case in the criminal division rather than in the family. Last year, you added 3 offenses to that list and took one away. Now you got a total of 14. So you got these big 14 offenses. So generally speaking, keep in mind, generally there's exceptions to this, and there's a third option called youthful offender. We don't need to get into too much detail right now, but generally speaking, if the young person commits one of those more serious offenses, the Big 14, their case will start in the criminal division, at least if they're age 14 and above for 11 of them, and age 16 and above for 3 of the others. So the age is also a factor, but if you keep that in mind, generally, is it a Big 14 offense or not? That's a crucial factor to think about. If it is, most often they're going to be starting in criminal division. The other point is, this is going to segue us into the language of the bill. They said, all right, well, that's the offense. What about the age range? Well, the age range is, generally speaking, the family division has jurisdiction over when it's a non-Big 14 offense, right? Because you got the 2 categories: Big 14, everything else. There's one of the everything else, which means a felony that's not in that 14 list or a misdemeanor. They will typically start in family division. But what is the age range of those cases that start in the family division? Low age of 10, high age of 18. So it's 10 to 18. Now, as Jay was getting at, up until 2020, the high age was 17. So it was, when Raise the Age was first passed in 2018, it had 2 steps. It was going to phase in raising that high number, right? So that the maximum age that someone could be when they were brought into the family division for a non-Big 14 offense, Big 12 at the time, but it's Big 14 now. At that time, it was the 18th birthday. So that was the maximum. So at age 17, you would, if you committed a chocolate thing, say, you would start in family division. But if you were 18 at the time, this is prior to 2020, you would have started in criminal division. In 2020, step 1 of Raise the Age becomes law, and that starts the 18-year-olds going into the family division. So it's from that point forward, 18-year-olds who committed one of those non-Big 14 offenses, they start in family division, right? And when the bill was passed originally, there was phase two, step two of raise the age was to add 19-year-olds also to the same way that 18-year-olds were being added, that were added in 2020. And that would had an effective date that has been delayed a few times over the years. I think originally it was 2022 and then 2023. And most recently, last year, 2024, you passed an additional delay, but that delay takes effect, is scheduled to take effect in a couple of weeks, April 1st, 2025. So that step two of raise the age, the one where the 19-year-olds start in the family division for non-big 14 offenses, that's going to take effect in the 18th, I think. Yesterday was St. Patrick's Day, right? Today's the 18th. So less than 2 weeks, about 2 weeks is when it's supposed to go into effect. So think about this, if you do nothing, if nothing done, the legislature takes no action, then raise the age for 19-year-olds, it goes into effect. So the proposal that you have in front of you that came from the House was to take an action. And the action that it proposes is to repeal that provision that says, all right, 19-year-olds go into effect on April 1st, repeals that, so it won't go into effect on April 1st. And it puts in a 2-year delay on those 19-year-olds going into families. So they go in, and if you want to look at the bill, for example, just to see what that is, you look at the very last page of the bill, the effective date, lines 7 and 8. So you see it says sections 3 and 4 take effect on March 31st. And the reason for that is that's because, as Dale was saying, the effective date of these 19-year-olds right now is April 1st. So you want to, prior to April 1st, you want to have something to go into effect that repeals that, but you want to repeal it before it goes into effect, right? So that's what that does. Subsection C says, all right, since that's repealed, we're going to have those 19-year-olds go into the family division, but it's not going to be for 2 more years. So that's why it has that July 1st, 2027. Okay. And then in the meantime, between now and 2027, as long as we're on that topic, turn back to page 6. In the meantime, the language requires the Agency of Human Services to make a couple of reports to you folks, this committee, have Judiciary, Joint Justice Oversight, as to basically their progress on implementing raise the age. This is very almost identical to the language that was passed last year. If you remember, that you required bi-monthly reports for the Agency of Human Services during last interim, prior to this April 1st effective date. So this is very similar to that, other than there's a provision added, page 7, line 14, that subsection B, that's new, having to do specifically with the Red Clover treatment facility in Virginia, adding some language there that wants its report that also sort of includes some data on utilization of the Red Clover treatment. So that's new. Other than that, that's basically the same with 49% of the times 148 last year. So that takes care of the raise the age piece of this. The walk through that, just one other last bit of explanation, which is sections 1 and 2. So we're talking about the top end of the age range and the juvenile group, right? But the high end, which is right now 18, right? 18 is the family court. As I mentioned, though, the low end, it's age 10 through 18 right now. If you commit a non-big 14 offense, you're age 10 to 18, your case starts in the family. As well, actually, they're 12 or 13, and US big 12 offense starts at big 14, sorry. What this proposes to do then is to bump that lower age threshold up by 2 years from 10 to 12. So right now, let's say you're a 10-year-old and you commit shoplifting, right? You could be brought into the family division under this language in a juvenile proceeding. This proposal is, well, if that age range bumps up to 12. So if you're a 10-year-old, you can't be brought into the family division. You could, that shoplifting conduct could still be relevant in some other, say, a CHINS proceeding to terminate the child's parental rights, where it might be relevant because, the child, say, committing unlawful behavior might be relevant to the fact that they were beyond parental control or they were public safety issues, something like that. So the fact that the conduct might still be relevant in some other proceeding, but it could form the basis of a juvenile proceeding, the way it can now. So it only changed that for 10 and 11-year-olds, so they can no longer be brought in family division as juveniles, the same way that, say, 9 and unders can be brought into the family division now. So it bumps it up 2 years. So,
do we have any data or information about how many 10 and 11-year-olds are being brought in through the family division in a given year?
I can only, I don't have data, I can only say anecdotal that the testimony in the House was very few. But I think that, for example, Marshall Paul had some testimony on that, so he might be a good witness to ask that question too.
Yeah, I think the issue might be that they're confidential. So it might be difficult to get that data, but definitely worthwhile to ask Marty about.
Right. Thanks. So a couple of last quick little points, and I'll be finished. So as I was saying, that lower age threshold currently is 10. So below 10, 9, 8, 7, whatever, you can't be brought into family division at all. There is one exception to that. One exception for that even an under 10-year-old can be brought into the family division on a juvenile proceeding. It's for murder. Right? That's the one exception. You see, those are lines 15 from 18 on page 1. There's an exception. An individual led for committing an act before attaining 10 it would be murder can be brought into a juvenile proceeding. So that's repealed. So it makes the law consistent. If you're under 12, can't be a juvenile proceeding against you, regardless of what the this one strikes the murder exception. That's that. Lastly, section 2, page 2. This has to do with extending the family division jurisdiction when the child commits the offense at an older age. So if you think about it, if the child ages out of family division at age 18, and they end up committing the offense when they're 16 or 17, then there really isn't that much time for the family division to oversee the case, for the DCF to have a juvenile probation plan in place for the kid, for the work with the juvenile probation officer towards rehabilitation. There isn't much time. So in law has been the case for many years that the family division has the ability to extend jurisdiction beyond that. In the case of a 16, 17-year-old, this is line 8, page 2, for example. If the child commits the offense when they're 16 or 17, family can extend jurisdiction until 6 months beyond the child's 19th birthday. Down below line 10, they were 18 when they committed it. They can extend it until 6 months beyond the 21st birthday. So the proposal is bump that by a year. It gives the family division more time. It's not a requirement, just to remind you that they don't have to do that. But if they think it's a case where it might be appropriate for the child to receive more services, to be under the jurisdiction of the family division for a longer period of time, to be able to have a probation officer a longer period of time, they can bump that up for an even longer period of time than they can now.
So this is not mandatory. This is something they can request, Eric.
Yep, absolutely.
How would they do that?
The state's attorney could file a motion. Anybody could file a motion. Court can do it on their own motion. I think it's a motion process that would permit the court to extend the jurisdiction if they found it was appropriate.
Yeah, I see we're taking testimony here. It's a little later here, but I'm just wondering as to 3 years, like the Senator Mathos brought up or something like that. It's quite an extended period of time. I just wondering what falls under that parameter, why they would press that. But fixed in 3 years, why do they need 3 years and 6 months? If they also going to be fixed, or we'll ask them.
Yeah, that's a good question for the witnesses, definitely. Yeah. What?
Oh, Senator Mathos' question, I'm just following up.
Oh, right. Good question.
Thank you.
Yeah, you bet. And that's all I have for today.
Thank you. Any further questions for Eric? Okay, great, thank you.
You bet. Thank you.
Matt, do you want to?
Yes, please. Thank you. I'm sorry. I got kicked off the Wi-Fi, so
Oh,
I'm just trying to get back in here. We're here now. Yes, right here.
Senator Burr, around.
You might show up, so if you don't mind grabbing another seat from the back. So we don't have to shuffle around here.
Yeah.
So, good afternoon. Matthew Bernstein, Child Youth and Family Advocate for the state of Vermont with the Office of the Child Youth and Family Advocate. With me is
Hi everyone, Lauren Higby, Deputy Advocate, Office of the Child, Youth and Family Advocate.
Before we get started with our presentation, we do have some data on the question earlier about the younger youth section one of this bill. Perhaps I will come back to it at the end if it's in a different presentation, but I just wanted to say that at the outset. At least Senator Matos here, new to us here in this committee. I think it always helps to kind of anchor who we are and why we're here. So the Office of the Child, Youth, and Family Advocate was created a little over 2 years ago through legislation passed by both houses and signed by the governor. And we, notably for this debate, are statutorily independent and nonpartisan. And that can have its downfalls, being independent. It can be a little bit isolating, but for issues like this, I think it is crucially important. And I want to emphasize that my take on this issue and our take on this issue is that it's become highly politicized. And what I mean by that is this bill has become a proxy for other things. And we'll get more detail on this in a second. So when we, I think there's some real credibility issues from a youth-centered perspective. In terms of how this body, the legislature, both houses have handled raise the age. And I think there is a real lack of youth voice, a real lack of a diversity of witnesses. And I think that's problematic, not just because children, youth, and families are suffering as a result, and there are real impacts of even just a 2-year delay here, but also because as a body, and if you look at the third bullet point here, one of our statutory jobs is to provide information to you, to the governor, to you, to the public, and others. And I think that, we will do that today, but I think there has been a real obscuring of the necessary information that you all need to decide on this important policy. And when I say this important policy, what I mean is keeping communities safer, promoting accountability, saving state money, supporting youth, affordability. All of those things are wrapped up in raise the age. And it is raise the age, not age 2. Raise the age is very strong legislation that Vermont really needs, and it really benefits Vermont. And we will talk about that in a second. But I just wanted to say that at the outset, is that we are here to advocate for children, youth, and families, and in this particular matter, older youth. So that is our bias. We're stating it on the record. That is statutorily what our job is. But most of what we're going to talk about today is really about the stated goals of raise the age, the stated goals of H2, the governor's goals in all of that. And I think I would really urge you all not to rush, because the April 1st deadline, you all created that, right? I'm just kidding.
No.
Not only that, but to go way back, Ms. Johnson mentioned Senator Sears, and may he rest in peace, and his presence, I think we all feel his absence every day here. I was not around in 2018 when this when Raise the Age was passing, but I've talked to enough people to know that this was really his passion. And his passion was not just youth up to a certain age. He really, Raise the Age would not be in law if it was not for Senator Sears. And he arrived at that through talking to a lot of people, through going on tours, through, a lot of work. You all knew him much better than I did. The initial Raise the Age legislation was part of a public safety omnibus package that the governor supported. It was passed by both houses. It was passed unanimously by the Senate. It was signed by the governor. It was deeply researched. And if you look at there's a report we mentioned here. We had an incredible collection of national experts. We wrote a great implementation plan. We looked at all of these data issues that we're going to be talking about today. And since then, we've slid backwards. We have thrown, we have spun our wheels on some of the data, on some of the policy, and we've tossed out all of the excellent work that we have done, or we're trying to do that. So I will move on, but I wanted to say that at the outset, because I think I think we're really missing the boat on what's going on here. So here's our summary of our offices, just to be clear at the outset of our positions on H2. If you're asking us up down today on H2, we are opposed to that. It does too little and too much, I think. It is harmful in that it delays raise the age, and it doesn't do enough to patch up. It doesn't address its own goals for why we are delaying raise the age. So if we take individual components, says my internet connection's unstable. We oppose delaying it. We support the reporting requirements in section 10. We have some amendments. We oppose extending juvenile jurisdiction. On this one, I think the issue is I've heard that DCF is not ready to implement raise the age, and yet what H2 proposes to do is assign them more work, right? We're saying on one hand, they're overwhelmed, they can't implement it, and then we're extending juvenile jurisdiction, which puts more onus on them. So I don't quite understand the tension there. And then lastly, and I put this last on purpose, raising the minimum age of jurisdiction. Representative Lalonde said on the record that the reason that section 1, raising the minimum age, was added to this bill is that he didn't think he could get the votes on delaying raise the age unless section 1 was added to the bill. What section 1 does is something that essentially there's a full consensus on. I agree with Ms. Johnson on that. I testified on this bill in its initial iteration. All it did was raise the minimum age. There was consensus on that. I think we could do this. I think there was calls in the House to separate out this provision. That sounds great. I think if you next session or whenever ran this provision separately, it would sail through. The impact, and I have data on this, is relatively minimal, and that's why I put this last. Because as Defender General Paul testified, even with the current law, there's very few children. There's incredibly few children who are even charged. There's very few, I think he said, if not zero, who have been found competent to stand trial, regardless of maintaining the law. So those are our positions. And again, to come back to the goals. Increase public safety and accountability, support DCF, ensure appropriate treatment. I think we can all agree that those are the goals of this. We agree with that. And the reason why we're in opposition to this is that we don't think it does that. And we've got the information. Why? Okay, so I'm going to go through this part, but this is basically all the bill does, right? This H2, we're talking about H2 now, not raise the age. H2 does this, and really that's all. So it delays raise the age for 2 years. It extends delinquency jurisdiction, as we've been talking about, another year. It raises the minimum age, which, as we talked about, has minimal impact. It requires 2 additional supports from DCF. In the past, from our perspective, DCF has presented a lot of data that is completely irrelevant, unfortunately, to actually being able to understand the impact of phase 1 of raise the age, which provides us with a perfect experiment, right? If we want to know what the impact of 19-year-olds are going to be, the first thing to do is study 18-year-olds. It's not necessarily going to be the same, but we're already doing this law, right? And this is all H2 does. So what doesn't it do?
Can I interrupt real quick? I just wanted to clarify that your opposition to section 2 is because you're concerned about the additional workload that would put on DCF.
Yes, and frankly, if other parts of the bill made sense, I honestly, we don't feel that strongly about section 2. To be truthful, it's as we discussed earlier, an option. I would call it optional. It is not mandatory, right? It's before the court whether jurisdiction is extended. If we're saying there aren't relevant services for children and youth, and we're saying there's a problem with getting them to engage, I'm not sure how adding another year onto that would help that problem. It's sort of like the old comedian line, like about the restaurant. The food is terrible and the portions are so small, right? Like, I'm not sure what it does. So does that answer your question?
Yes.
Okay. So what doesn't it do? We can argue about this. I think, there are a lot of studies that show that recidivism, that raise the age, reduces recidivism. One key concept here that I think is important is, when you're talking about a 19-year-old and you're saying, well, the juvenile system can't handle them or it's not working out, it's just important to remember that if the juvenile system isn't handling them, then the adult system is. And so we can't just look at, oh, the juvenile, this young person is going to sign themselves out of treatment, or there's not enough court control over them, or they can't remain incarcerated. We have to think about what would happen to them in the adult system. And the reason why raise the age reduces recidivism is it removes adult consequences from people whose brains are not developed. And why that's important is when those folks go into the adult system, it honestly makes them more likely to meet folks who are engaged in criminal activity, to be swayed by those folks, to make decisions in groups, right? This is what the brain science says. So that's why the recidivism is reduced by raise the age. And that's why we need to think about, if we're talking about, we want accountability for a 19-year-old, what the accountability in the adult system is, as we heard earlier, you're ordered to produce your mental health records, you're ordered to this treatment, and if you don't do it, you're going to jail, right? I don't know what other accountability we're talking about. Because a 19-year-old who's treated in adult court can sign themselves out of a program in theory too. The reason why they won't is the court has leverage over them, right?
I think another way to look at that is to, look at the definitions and other research, in that it shows that when you have the lightest touch or the lightest intervention on emerging adult populations involved in the justice system, that has more of an impact to desist from further delinquency acts than their involvement in the adult system.
Right. And again, that implementation report gives the research on what we're talking about.
Yes. When you talk about recidivism and raise age, how many other states have this implemented already? Age 19?
Zero have it implemented to where we are right now. We are leading the nation right now, where we stand.
So your data or whatever else is taken from which state then? Just in cause.
I don't know that answer off the top of my head.
But you guys said that it reduces the recidivism rate by putting them in the
Right.
program. But you don't have the data to show us.
I can send you studies. If your question is, was that done on people, young people younger than 18, 19 or 18, then the answer is that is true. It was.
I'm just gonna
Actually, and I don't actually honestly know that. I'd have to check the research. I'm not as much of an expert, but I appreciate the question. I think that's a good question.
Thank you.
Are we going to hear from the Columbia researchers that did the research from showing us?
Lael, I think was that? Yes.
So this is another key thing, and this is where the politics come in, is that what I've heard, and I think I've listened to all the testimony on this, Bill. What I've heard repeatedly is DCF needs resources, right? And we heard this in joint justice, years ago, since the very first hearing that I attended about this a couple of years ago. That's been the issue. And from the very beginning, this has been something that we have supported. We completely agree that DCF's resource issue should be addressed, that the workers need support, they need support building programs, all of those things. I think, 2 sessions ago, they actually asked for this in their reports. They asked for $1 million for the barge program, the restorative justice program. And right now they're not asking. Right? And so this, I think that's problematic. If we're saying we're delaying raise the age because DCF needs time to get up to speed, right? It's been almost 7 years since this law passed. And if DCF were working every day on building programs, and I don't want to say they're not, they are, of course, but I'm talking about at higher levels. The resources need to come to flow to DCF. We think these will save money, but H2 doesn't do that. We talked a little bit about accountability. The main thing about accountability here, again, is, some young people will do things like we heard earlier, sign themselves out of treatment. There might not be a good program that matches them. They will be recalcitrant. They will do that regardless. These young people will not cease to exist because they're not in the juvenile justice system, right? If we don't implement raise the age, they fall into the adult system, and they don't act that much differently, right? I mean, I would like to tell you that a 19-year-old, the average 19-year-old who has a judge in front of them telling them, if you don't do this, then this thing's going to happen. But that's exactly where the brain science comes in, right? Think about yourself when you were 19 and the decisions you made, right? This is, it wasn't just you. And so, H2 does not, it doesn't address this accountability issue. It doesn't have an effect on prosecutors' ability to charge older youth for serious crimes. So this is the other side of the safety issue. We have the big 11 plus 3. We added to that. It's the big 11 plus 3, as I say it, because we added 3 charges partly in this committee last year that have slightly different rules than the big 11. That's why I say plus 3. We have, as we heard earlier, the youthful offender statute. H2 and raise the age don't affect those. In fact, what they do, if on April 1st, the second phase of raise the age goes into effect, what you're going to have is fewer youthful offender cases going forward. Because a lot of the 19-year-olds who would have been youthful offenders will now be charged and just be in the juvenile court. And why that's relevant is there is a resource issue with the so-called ping pong effect, which we'll talk about, and which we've heard testimony on that before. There you go. Thanks. This is a problem. What this is cases bouncing back and forth between the adult criminal court and the family court. And we heard testimony from Judge Zone and from Defender Paul on this. They are part of I'm not sure what it's called, a working group to work on this issue and bring proposed legislation. That's already happened. The gears are turning on that. That's necessary work. If we delay raise the age, we get more ping pong effect until that can be worked out next session at the earliest, and we increase our resource problem on courts. H2 also doesn't help Vermont's system of care. This goes back to the resource issue. It doesn't build community services, and honestly, we'll talk about this in a second. This thing where raising the age supposedly creates a need for more locked facilities is a misnomer. It's not accurate. And then the last thing is this H2 does not generate meaningful data. We'll go into more depth about this in a second, but the data reporting requirements here, again, we have some suggested amendments, so those might help from our perspective, but the data reporting has not been helpful so far, I don't think, and it also doesn't help us save money for the reasons about before. Oh, I forgot the last one. Last but not least.
Senator Matos has a
Apologies.
No, I'm just curious. What's your definition of youth?
In which bullet point?
Just anytime you use the term youth, what's that age range?
Good question. It's a general term. So are you getting to the consistency issues with how we define a youth?
I'm just curious. Yeah.
I think that's I think it's with respect, not just us.
Yeah.
We have ages all over the place. We have how many folks, but we have, when you're 18, you can control your own health care. Thank you. It's just 21 math people.
21 out.
If I'm 23 and I try to go rent a car by myself, right? That's a what are the bean counters who do that? It's an insurance issue, right? But it's been it's not amortized, there's a word. Anyway, they don't take risks on 23-year-olds driving cars, right? You can join the military at a certain age. I don't know what the age to buy cigarettes or alcohol. 21 now. You can be on your parents' health insurance until 26. So I'm not trying to distract from your question.
What your office considers youth, like who do you represent?
I mean, if you're going to force me into an answer, I would say, pre-birth up to 26. But that's not, I wouldn't say every bullet point has that.
No, I was
just worming out of your question.
I was just curious.
Yeah.
So I think it does have good range depending on the topic you're speaking about. When I say youth, I'm probably within the range of 16 to 24, sometimes up to 26 if we're talking about insurance. I think when we're specifically talking about a DPF program, we'll raise the age, and we're grappling with who's eligible for that. So it could be between, H2 modifying the 16, 17-year-old up to the 20th birthday. I also think given our jurisdiction over the Department for Children and Family, not jurisdiction over, that sounded wrong, but with our mandate, serving the divisions within DCF, that is where we see a larger age range. But then I also think of commissioner designated shelters, and they serve, 12 up to 24-year-olds potentially. So it does change depending on what we're speaking about. But I think that's a relevant question, no matter what the discussion is.
Yeah.
Yeah.
And again, I recommend, I sent to Chair Hashim, Dr. Andrea Green at the University of Vermont, who is a pediatrician, who works, she's a pediatrician, but her specialty is New American communities. And I spoke with her on the phone yesterday a little bit, and she sent me a lot of resources that I honestly didn't have time to look through before today. But I would recommend having her in to talk about development, because she was really instructive from helping, me process these questions. And I'm not gonna try to speak for her. I would recommend her.
Senator Lopez, yeah.
They do, and I'm wondering, they may get to it, but I'm wondering if you have, under the current, where we are currently with Raise the Age, how many people are we talking about? How many 18-year-olds are we actually talking about?
That was a great segue question. Okay. Is it appropriate for me to say we're going to get there?
Yes,
okay,
it is.
Thank you. I'm not sure. Okay, so if you'll forgive the rhetoric, I will say it has been very frustrating to hear a lot of statements thrown around that I think lack of factual basis in the course of this testimony. So again, I talked about this earlier, but supporting the barge program and giving DCF resources is the best way to support DCF. H2 does not do that. And here's where DCF truly deserves credit. And when our office was created, there was a lot of concern that we would be adversarial with DCF. And I have been pleasantly surprised, I suppose, to understand how much we've actually collaborated with DCF to support them. Because one thing, for example, they have done so well is they have reduced their own caseloads. Because they've reduced the number of children who have come into care. They have eliminated, eliminated is not a great verb. They have, they have made a real effort to ensure that children, that poverty is not the central reason that a child comes into state custody, is removed from their home, comes into foster care. And they have lowered their caseloads significantly. So, and I have this data, but, 5 years ago, they were in the 1300s of number of children in state custody, and now they're below 900. And that has a huge effect on their caseloads. And we have data to show that in a second. To start to get to your question, Senator Vyhovsky, the answer is a handful of new cases. In terms of DCF caseload, so the key distinction here is you want to look at the number of cases that are filed, and we have a slide on that in 1 second. But then the whole point of Raise the Age is what you want is most of those cases, you don't want them to come under DCF caseloads. Raise the Age focuses primarily, not exclusively, but primarily on low-level, essentially misdemeanors, right? And the whole point of Raise the Age and the whole point of the criminal justice system is to get folks who can turn their lives around fast out of the system as quick as possible with the right supports. And so as a result, not every case that's filed comes onto a DCF caseload. You're going to divert a bunch of those. They're going to be community service. There's different kinds of diversion. And so there's, on the next slide, we have, so this starts to answer the question of just a few cases a month. DCF caseloads are, sorry, I wanted to, let me pause. Sorry, I moved too fast. No, let's just keep going. So I lost my train of thought, but I'll come back to it. The answer to your question, Senator Vyhovsky, is a few cases a month. The other thing to understand is that related to what I just said, DCF caseloads are at truly historic lows, and there's a chart on the next slide. And then there's this point that I made earlier about youthful offender cases will decline when Raise the Age phase 2 goes into effect. Delaying it means more youthful offender cases, more ping pong, more use of resources. So here's the caseloads, and this I did not make this chart. This is verbatim a DCF chart that they obviously are mapping. And just to explain this, because we spoke with somebody high up at DCF yesterday who explained this, because I wanted to be sure I got it right. So the blue line, which is generally the lowest, is the caseload number if the department was fully staffed. So if every position was filled. The reality is there's a number of vacancies throughout the department, and that's been a longstanding problem. So the red is meant to adjust for that. So, and this is,
I just want to
sorry,
be
go ahead.
clear too, that this is for Family Services Division, not the entire department for children.
Thank you. Sorry.
Yeah.
And it's also important to clarify that Family Services Division, at least on paper, each of these family services workers, right, who are the workers who work directly with the young people, these are all mixed caseloads in terms of juvenile justice and child welfare. So, you know, it varies obviously by department and by office and worker, but there aren't workers who just do juvenile justice or who just do child welfare, right? They're all mixed. So, which is relevant to this discussion, right? So the red line is an adjusted, they have a formula, there's a statutory, it's statutorily set that it should be 12 families per worker. And the person at DCF told us that was when the legislature instituted that 12 families per worker, it was a huge boon to the department because it was a manageable number, but also because then it could compare apples to apples over time. So the red is an adjusted number based on the 12 families per worker, and then the green line is the aggregate. So, and again, there's a formula on another page that's somewhat complicated, but the thing to understand about the green line is the higher it is, the better. The over 100% capacity means that the department has more capacity than it needs. And I'm putting that in air quotes because we want to make sure we don't say, oh, there's workers sitting around with their feet on their desk doing nothing, right? That is absolutely untrue. This is very hard work, and DCF is struggling to attract new candidates because this is very hard work. So, another interesting thing to note about this is, first of all, you can see in 2018 when Raise the Age was initially proposed that it was actually, they were especially relative to today, caseloads were pretty high. And, again, there was a lot of consensus that Raise the Age was the right way to go. The other thing to notice is, I don't know what the reason is in 2021 where the red line starts to go up a little bit, right? And it goes above the green. Perhaps that's Raise the Age phase 1. I don't know. But the bottom line is that whatever that blip was, things have substantially settled out, and and DCF is stable, right? It's things aren't perfect, but this is just meant to say, we heard, and in fact, like,
I think what's important too is to look at the actual adjusted capacity to see across the state what the capacity is below the 100% target, and then review this information against the Raise the Age progress report. And what is most concerning to me is the vast discrepancies between what we see across the state, that there is capacity for family services workers to take on additional workload, and then what is recorded in the Raise the Age progress report from January 31st, 2025, specifically on page 16, when they're looking at the Family Services Division Juvenile Services caseload. They specifically note that they are lumping together CHINS C youth, CHINS D youth. So CHINS C is your quote unquote unmanageable. Let's change that word, please. CHINS D, truancy, youth engaging in delinquency behaviors, and youthful offender status. So I think what has been challenging, talking about the data question, is that the data that has been presented by DCF to show that they do not have capacity is actually combining multiple groups of children and youth that they are already mandated to serve and will have to continue to serve. And what I see when I look at the statewide data, they have done tremendous work to lower the gate to get families into the DCF system, and that results in capacity to take on 19-year-olds.
Yeah, thank you. Going back to the 2021 blip, I recognize you say you don't know what it could be, but I wonder if there's been any look into if that was due to the COVID shutdown and children suddenly not being in school, which is a safe place for many children. Like, I think, sure, I suppose it could be raise the age, but I think it's probably more likely that it is the fact that we shut down our entire society and locked everyone in their homes.
Right, and I think, you know, I don't want to be negative, but I really think that this body needs relevant information because that's the kind of debate we should be having. That this is a real policy debate. This, and I'm sorry I didn't put this in the slideshow, but this is the DCF report that Lauren was just referring to. What on page 16, this is the January 31, 2025. It says DCF FSD Juvenile Services caseload, and there's bars just going up. But it's just not relevant. Like, this is not raise the age. These are things that the department is already working on. It has nothing to do with raise the age. I'm not even sure where these numbers come from. But if we're talking about caseloads, which this uses, those are the caseloads. They have this data. This data is, I mean, I just had to, you know, do a screen grab. It's right there. So, I mean, it's not, the point is not DCF's doing this wrong. The point is that this really matters to children and youth, right? It matters to have the right information before you. And saying we have to rush because everyone agrees. I mean, the other thing I just have to correct on the record is that there was testimony in this committee that there was only one individual who was against raise the age in the House Judiciary. And that was a reference to me, I believe. But first of all, I'm not an individual, right? I'm the Child, Youth, and Family Advocate. Second of all, our office is an entity, right? There's only two of us, but and also, like, that was a direct function of who was called to testify before that body. And, you know, we work in government. Like, our job is to ensure that the state saves money. And, you know, we don't want to just like have bad policy that helps kids at any cost, but we have to have relevant data. And so I'm sorry, I don't want to get frustrated, but it's just, this stuff really matters. And it's been really hard to be part of this again and again and again. And to think of going through this for another 2 years is, frankly, it's just a waste of time. It's a waste of your time. It's really a waste of everybody's time.
I think
When what we should be talking about is this real policy. Like, let's talk about getting DCF those resources. We're here for that. Sorry.
I would also be curious, and I haven't seen this data in terms of how DOC caseloads will be impacted if we have youthful offenders that potentially will shift to raise the age, how that shared caseload between DCF and DOC for youthful offender youth. Generally speaking, right, depending on the age of that youthful offender, how that will shift DOC's capacity as well. And I haven't seen any data to speak to that. So that would be an interesting question to pursue.
Yeah, we're coming to the end. Don't worry. So this, I think, more squarely answers your question, Senator. So let me just explain what this is a little bit. So this is court data that we got again last year. That's why it's the dates it is, because this was for this previous round of this. On the right, you have misdemeanors for 19-year-olds. So this would be adult court. So this is at the same time, but you're looking at two different ages in two different courts because, raise the age 1 means that 18-year-olds become delinquencies, right? Misdemeanors become delinquencies. And because raise the age 2 is not implemented, 19-year-olds are criminal court misdemeanors. The bottom line here is, I think the last line, there was an average in here somewhere. It might have gotten cut off. The bottom line is it's about 10 cases. It varies, but for both sides of this, it's about 10 cases a month. And as I said before, that's cases filed. And I don't think this is deduplicated in terms of cases. So there may be fewer. Sometimes there's 2 cases in 1 person, right? So you have to reduce it by that. And then, as you see the quote on the right, an analysis of the current delinquency caseload in the family division and the cases of 18 and 19-year-olds now prosecuted in the adult system, that's because this is from 2019, indicate that approximately half of these cases can be appropriately diverted, making the overall caseload of delinquencies cases manageable when raise the age is fully implemented.
And so from that roadmap, we want to apply it to the Raise the Age Progress Report from January 31st, 2025 that DCF submitted. And on page 17, they count all 19-year-olds that have pending criminal division cases at the time of the offense across the state. And it does not dissect or spread out, how many will be sent to diversion, how many will be served by barge, how many are fine only,
How
right?
many are youthful offender? A lot of these people, these young people on in the DCF report on page 17 are already on DCF. Or maybe they're not, I don't know, but they don't, it's unclear what the data is showing. So the answer is 5 cases a month, ish. 5 cases on DCF caseloads, because reducing it by 50. Thank you for the education. All right, and then accountability, we've already talked about a lot of this. Okay, I just want to say the accountability problem, I think, is vastly overblown. And again, that's a policy debate. That's fine. All right, so facilities, okay, and this is an important issue that we've only touched on. So we've heard multiple times in many hearings that Raise the Age requires additional locked bed capacity. We do not believe that Raise the Age itself requires the need for essentially that it is a negligible amount of locked bed capacity that Raise the Age adds to what is already on the plates, on our plate as a state. This last point is maybe something that you may not know, maybe you do. I think it's not been said. It's not a great thing, but youth charged as adults can be held in adult facilities under federal law. There is no federal prohibition on that. There may be programmatic and other barriers to that. There's from our perspective, from a youth center perspective, there's huge problems to that. But it's on one hand, we're charging youth as adults, saying they should bear the brunt of the criminal justice system. And on the other hand, we're saying we're worried about them, in a facility. So, I think this ties into the bigger debate about, do we need a youth locked facility? And we heard earlier that we don't have one. We do have one. We have one right now. The Red Clover Treatment Facility is a locked juvenile facility. It's 4 beds. It's operational. We think that 4 beds might be sufficient, and this bill has a provision to track data on that was, I believe, added at our suggestion in the House Judiciary. Maybe it's enough and maybe it isn't. We'll put our chips on the table and say it is, and let's measure that data, and then let's see before we go out and break ground on a new, hugely expensive, I'm going to say $50 million facility for 12 beds that is not based on a shred of data that we've seen. There's no data to back up 12 beds for a new facility, let alone they were talking a little bit about having more. We need a facility. We have one. Let's track the data.
To Ms. Johnson's point in terms of the history of Raise the Age, I think it's important to note that when we had the November 2019 Raise the Age implementation report that really spelled out every step we need to take to implement this law correct and thoroughly, in January 2020, DCF and the administration made the recommendation to close Woodside. So they knew that they did not need a locked facility in order to implement Raise the Age. And then July 2020, Raise the Age went into effect for 18-year-olds without a request for a delay as the October 2020 Woodside closure date approached. So I think the history of Raise the Age is important to inform the discussion of facilities now.
And I'll add 2 things about Woodside. The capacity was I believe 5 or under when it was closed. And second, there were other reasons that Woodside was closed, as we all know. I think when we think about facilities, it's from a youth center perspective. I spared you today in the slideshow a whole host of headlines about horrible abuses that occur at youth facilities from all over the country. But keep your eyes open, because you'll start seeing them if you start looking. They're everywhere. And it's not to say that every carceral place is gonna be abusive, but it is to say that kids don't do well in locked facilities. So, some of the phrasing in the data part of this too is sort of, it implies that what we want is locked facilities as opposed to what we want is to prevent the need to have locked facilities, right? All right, so then the other thing that's just important to keep in mind is that neither federal nor state law prohibit youth charged as juveniles from being held in DCF locked facilities. And here, youth, I would say, includes people over 18. I think I should have specified that. It's definitely includes, the whole point of this is that there's been a misnomer that you cannot put a 19-year-old in a DCF facility for youth. And it is a serious issue. It's a program development issue. It's having the right services. It's having the right milieu. You obviously don't want to put a 19-year-old next to an 11-year-old, depending on age and development, et cetera. But, there's nothing magic about it, about a young person turning, from 17 to 18, 18 to 19, right? It's all about the individual and age and development maturity. Okay, we are almost done. So as I think I already did this, there's no evidence to support 12 beds. I just want to say that on the record again. Safety. So I think we already talked about this, but this is from the Raise the Age implementation report. The 2 points here are nearly all youth, not all, but nearly all youth mature and age out of crime if given the opportunity to do so. And less can be more when you're talking about young people, right? And if they fall into the justice system, they become more likely to reoffend. So we are not there. Okay, so here's our suggestions for amending, and remember.
Matt, can I interrupt you?
Oh, please.
We do have 2 other witnesses, and they only have about 20 minutes. Do you want to present your amendments later in the week, or will we be done in about a minute or 2?
We can finish up real fast. Thank you. So, our top suggestion is to do nothing, to vote down H2. You really have to do nothing. Okay, so sorry, I don't want to rush. The first one is the most important. Remove if this is an implementation problem, take out misdemeanor, take out anything that would be a misdemeanor from this bill. So if you're saying, okay, we're worried about felonies, 19-year-old felonies coming into the family court now, then let's take out the misdemeanors. Let's not take them out of the bill so that they will go into effect April 1st. Makes sense? Reduce the 2-year delay to 1. I'm not sure why it's 2. I mean, I know why it's 2, because you all don't want to have to do this next year, but why do we want to do it 2 years either? And then relevant data. The most important thing is to disaggregate. We kind of already made this point, but just disaggregate all the irrelevant data points and just have useful data. So track raise the age youth, not big 11, YO or chins in secure facilities.
Senator Bohoski.
I'm sorry.
No, I want to be clear, your high level hope is that we do nothing.
Correct.
But if we refuse to do that,
Yes.
those are the suggestions for change.
Correct. Yes. So and then it's track secure youth and facilities. Track raise the age youth specifically in secure facilities, right? We need to track utilization of Red Clover, but also how many youth, particular to raise the age phase 1, are in that facility. Track youth who have active or past GINS involvement. Again, there can be confidentiality issues here. Our office can help with that. We are inside that bubble, and we can present things to you. So instead of wasting more time on delaying raise the age, let's support DCF, address the underlying issues, create the services. There is a cost to another delay, and we invite you seriously to come take some tours, talk to some youth and talk to facilities, because that's really what's been missing from this conversation. And that's what Senator Sears did. That's why we're here today, many, many years later. The first phase was implemented successfully. We're ready for phase 2. And this last one, it sounds a little ominous, but really, to flip that point on its head, that we're the only one doing it. There are other folks watching us, and if it's not working for us, then okay, I can see why we wouldn't do it. But given that it is working, we should stand up and be proud of it. And it does influence policy in other states. And if it's the right thing to do, and here's where, honestly, last thing, folks who are saying to us, we think we should repeal raise the age. I totally respect that, and I'm willing to have that discussion. What I think is hard to hear is we support raise the age, and I'm talking to any legislator now. If you're saying you support raise the age, then you should vote against H2. Because raise the age should go into effect now. We should do it. Delay it. I think why I respect people saying they want to repeal is that's what I think delay is. I think it's a step to repeal. If that's what you want to do, it's great. Put your opinions on the surface, and that's, I totally respect that. We're nonpartisan, right? But if legislators want to support raise the age, let's let it go into effect.
Okay, so it is my understanding, and you may not have this information, that while no other state has completely gone through the process, there are other states that are using the pilot in Vermont to move forward similar
Thank you.
legislation.
I believe that's correct. And Lael Chester from the
Okay.
Columbia Justice Lab would be the expert on that.
Perfect.
Thank you.
If I can just say one last thing, since I am harping on the historical implications and why we passed this initially, I feel like a lot of our recent discussions in this new biennium and in the last biennium has failed to recognize that this was a major racial justice piece of legislation for our state as well. And that has not been acknowledged, I think, in this session. And so I do not want that to go unnoticed or unexamined.
Thank you.
Thank you. We still have Tyler and Lindsay on the Zoom. Oh, great. So Tyler and Lindy, thank you for your patience. I know we only have 10-15 minutes left until we have to adjourn. So I wanted to ask if you want to put out some initial points, and then we can provide you with 45 minutes later in the week or however much time you need to come back. Is that later, or how would you like to?
I am prepared to share the thoughts from Deputy Commissioner Radke. If the chair wants to do that now, or we're prepared to come back Friday. I think that was presented as an option for us if we didn't have time today. If the committee would prefer that we just provide all of our testimony on Friday.
Okay, it was a little bit hard to hear. I heard Stephanie coming back in on Friday. We can move bills around tomorrow morning. And we have between 9 to 10:45. But also, since, I mean, if you're not going to be presenting anything today, we can also just adjourn and follow up with scheduling and agenda planning through our committee assistant as well.
Yeah, whichever you prefer. We can certainly start our testimony if you would prefer, or if it's easy to just do it all at once. I'll leave that up to you.
Okay, I prefer just having everything in one fell swoop, so it's not disjointed or anything like that. So, sorry you didn't get to present today, but I just want to make sure everybody has plenty of time to do that. And so, I'll follow up along with our committee assistant to make some plans either for tomorrow or later in the week to give you guys plenty of time to do that.
Okay, great. Thank you.
Thank you.
Of course.
We